This is Chad Brown with Chad Brown Law. I hope you're doing well. I am continuing today talking about the five-step sequential evaluation process that the Social Security Administration goes through in every case to determine if someone is disabled. I have already gone through the first three steps: substantial gainful activity, medically determinable severe impairments, and listings. Today we're going to actually get into the first step where they look at whether you can actually work. And a lot of people come into the system and they think that really only the question is can they work or not. A lot of them think can they only do the job they've been doing. And honestly, in the system, we don't ever get there till the fourth step, which we're going to talk about today, which is past relevant work. So let's get my little drawing back out. And here we are. We're in the sequential evaluation process, and we're going to be at step 4. And today we're looking at past relevant work. Now, just generally, past relevant work is jobs you've done in the past. So if you think about the disability process sort of in a very broadly, they're trying to determine if you have if you're not working or working very little because of medical impairments, and those medical impairments are keeping you from being able to work. So the first stopping point with work are jobs that you've done in the past, or what's called past relevant work. Now, generally, if you can do past relevant work, you're not going to be found disabled, and you're going to lose at step 4. If you cannot do past relevant work, then you don't actually win your case, then you go to step 5. So what is past relevant work? It's actually very specifically defined by the Social Security Administration. It has to be relevant work performed in the past. Okay, I realize, that's the obvious. Well, what's that mean? Well, the past relates to performed within a relevant time period. Generally, the look-back time period is 15 years. 15 years from when? Well, it's either 15 years from when you allege you became disabled, or it's 15 years from the date of the hearing. Really, it just depends on who the judge is. Honestly, there's a lot of confusion about how the rules applied. Generally, what we do is look back 15 years from the alleged onset date when you say you became disabled, because that's the time frame relevant before you're saying you became disabled. So there's going to be a 15-year look back at jobs you've done, which becomes an issue with people. A lot of people are like, well, golly, I don't even remember what I did 15 years ago. Or I did that job a long time ago and now that job doesn't even exist in my community. But you have to remember, the only question is, could you do a job you've done in the past? If you can do a job you've done in the past within this relevant time, then you're not going to be found disabled. So then you run into issues of, well, I worked here full-time for like 7 years, and then I had a bunch of little temporary jobs. What about those? Okay, so past relevant work is performed within a relevant time period. It also has to be performed at SGA. SGA, you remember, is a step 1 of the process where they look at countable income, which is money that you earned minus any impairment-related work expenses. So what is SGA? Well, SGA actually differs from year to year. So what is SGA for today in 2020 is not the same as it was in 2019 or 18 or 17. So they have to go back and look at the years you performed the work to see if you performed them at SGA for those years. So if you did a job for, say for example, in 2010, then the question is going to be, you performed that job, but did you perform it at the SGA level for 2010, which was a different amount than it is today? If you didn't perform work at SGA, it's not considered past relevant work. And we see this a lot with temporary type jobs and transitional jobs as people move from one job to another, or part-time work. That job is not going to be counted against you. And then the other thing they look at is, did you perform the job long enough to learn how to actually do the job? So sometimes people are in temp agency type jobs and they kind of float from one job to the next, and they never actually spend enough time learning how to do that job. Now, how long it takes to learn to do a job is also a debated topic in Social Security. Usually the court's going to rely upon a vocational expert to talk about whether someone worked a job long enough to be able to learn the job. Usually they look at what's called SVP, or specific vocational preparation, to determine how long it takes to learn a job. Once again, though, you get a lot of variance with judges. A lot of times the judges will say, did they do the job for 6 months? did they do the job for 3 months? And that's really not what the standard is. But if you're in a court and that's what your judge is looking at, then obviously that's the what you have to show them. So at step 4, what we look at is past relevant work, shorthand, jobs you've done the past 15 years, that you did at SGA, that you performed long enough to learn how to do the job. And then it's just the question becomes, do your limitations and impairments prevent you from doing that work? If they do, then we go on to step 5 of the process. But if the court determines you can go back to performing past relevant work, then you're going to be found not disabled, and the process is going to stop there. There's actually a lot of other factors that go into past relevant work, including how your job, what makes up that past job. Is it a composite job, which means you did a couple of jobs together? There's really a lot of different issues there that I can explore and probably will explore in some other videos and content. But for general kind of basic purposes, last 15 years, performed at SGA, you did the job long enough to learn it. If you can do those jobs, you're going to be found not disabled. If not, you get to move on in the process to step 5. Thanks.